California eviction notices. Before a landlord in California can evict a tenant, they are required to first terminate the tenancy by following procedures stipulated by state law. Notice for termination with cause. 3-day cure or quit notice. This notice is given when the tenant engages in activities that violate the rental agreement. This notice gives the tenant 3 days to correct the violation. If the tenant fails to cure within 3 days, then the landlord can file an eviction lawsuit with the court as provided under Cal. 3-day notice to pay rent or quit, pursuant to Cal, Code of Civ, Proca Section 1161, 2. A landlord can give a tenant a 3-day notice to pay rent or vacate if the tenant fails to pay rent when it's due. The 3-day notice typically informs the tenant that he or she has 3 days to pay rent, failure to which the landlord can file an unlawful detainer lawsuit at the end of the allotted 3 days. 3-day unconditional quit notice. California Code of Civil Procedure Section 1161, subsection 4, allows a landlord to issue a tenant with a 3-day notice to vacate if the tenant commits specific serious violations. The tenant is informed to move out of the premises within 3 days of receiving the notice. In this case, the tenant is not given an opportunity to correct the violation. The landlord can file an eviction lawsuit if the tenant does not move out of the rental unit within 3 days. The 3-day unconditional quit notice can be used if the tenant has caused significant damage to the property, violated the lease or rental agreement by assigning or subletting the rental unit, been late with the rent on several occasions, used or allowed the use of the rental unit for illegal activity, or created or permitted a nuisance at the rental unit. Notice for termination without cause. Month-to-month tenancy. If a tenant has lived in the rental property under a month-to-month agreement and the landlord wants to end the tenancy, then the landlord must inform the tenant with a written 30-day notice. Conversely, if the tenant has rented the unit for over 1 year under the month-to-month tenancy, a 60-day written notice must be provided to have the tenant vacate. These notices must provide information on when the tenancy will expire and that the tenant must move out by that time. Fixed-term tenancy. The landlord cannot end a fixed-term tenancy without legal reason until the end of the term. In this case, the tenant does not have to give the tenant notice to vacate when the tenancy expires, unless required by the tenancy. If, for instance, a tenant has a year-long lease that expires at the end of January and has not yet requested renewal of the lease, then the landlord is not required to give the tenant notice to vacate by the end of January. The notice must be served to the tenant using any of the 3 types of acceptable service in Los Angeles. The first service is known as personal service and involves the landlord or a hired process server physically giving the notice to the tenant. The notice can as well be left somewhere close to the tenant if he or she refuses service. The other method is the substituted service, in which someone 18 years or older in the tenant's house accepts the notice because the tenant is not at home. The third service option is posting and mailing, which involves mailing a copy to the tenant and putting another on the front door. However, this option is only acceptable if the other types of service have failed and a court order must be obtained in order to use this method.